Thank you, Mr. Speaker. With your permission, I rise to make two statements and trust that I could be brief, having regard to the fact that some statements have been made earlier today, which brings clarity to the issue on which I will make these two statements. Mr. Speaker, issues. Mr. Speaker, I'm a little disappointed, though, before I give my statement, that the Honourable Member for number 6 is not here.
He was summoned to Dominica.
Because, Mr. Speaker, I'm disappointed because, you see, Mr. Speaker, you indicated at the outset that you'd received notice 15 minutes before the Parliament started. And when you said that, Mr. Speaker, I acknowledge the fact that 7 days before
Yes.
the Parliament was convened, each of us had notice of the Parliament on the 14th. And so that is why I'm disappointed that pre-existing events, as he claimed, prevented him from being part of this Parliament today. And the statements really have to do with the conduct of this Parliament, especially the conduct during the period where the Honourable Member for number 6 presided as Prime Minister of the Federation. I say it's a personal statement because of how it affects me, Mr. Speaker, in my capacity as the elected representative for constituency number 8. You see, Mr. Speaker, back in 2012, when the Honourable Leader of the Opposition tabled a motion of no confidence, it soon turned out that months after, in fact 100 days after, the Parliament made the decision, or the Speaker made the decision, that the motion would not be heard. It caused me, Mr. Speaker, on the 22nd day of March 2013, to pen a letter to Senior Counsel Douglas Mendes. And for the record, Mr. Speaker, I will read some of it, because this is what initiated the motion, the case which brought this to this decision on the 7th of November.
Last week.
Yes, because you see, Mr. Speaker, I was concerned then that our fundamental rights as members of this chamber were violated by the decision of the Speaker and of the entire Parliament. And so on that date, at 8:50 p.m., the 22nd day of March 2013, at 8:50 p.m., I wrote to the Senior Counsel and said to him, "Thank you for taking my call earlier today, Friday, 22nd March 2013, and for giving me the opportunity to raise this important subject with you. As you are aware, I am one of 6 parliamentarians in St. Kitts and Nevis who support a motion of no confidence in the Prime Minister, Right Honourable Dr. Denzil L. Douglas, for a number of reasons set out in the motion. Yesterday, 21st March 2013, marked 100 days since this motion of no confidence was properly served on the Clerk of the National Assembly. The 6 elected representatives who constitute a majority of the 11 elected members of Parliament, all of whom have signed a letter addressed and delivered to His Excellency the Governor-General, indicating our intention to support the motion of no confidence, and who I'm sure will be willing to join as claimants in a case in the High Court of St. Christopher and Nevis, asking for a declaration and an injunction to restrain the Prime Minister from continuing to act as Prime Minister while the motion of no confidence remains untabled for debate. The letter went on, Mr. Speaker. We believe that this would be a landmark case in the Caribbean, and that you are the advocate best suited to take this case to a successful conclusion. On the 22nd day of March, we saw this as a landmark case, and we saw Douglas Mendes, SC, as the person best suited to take this to a successful conclusion, which we got on the 7th day of November 2017. The Speaker, this letter went on, of the National Assembly, Honorable Curtis Martin, in response to an inquiry from the Leader of the Opposition, Honorable Mark Brantley, has affirmed his acceptance that this motion must be dealt with expeditiously, subject to the exigencies of government business. Our rules of Parliament do not address how a confidence motion should be dealt with, but the standing orders of the National Assembly, Cap 201, Rule 85 states, in any matter not herein provided for, resort shall be had to the usage and practice of the Commons House of Parliament of Great Britain and Northern Ireland, which shall be followed as far as the same may be applicable to the National Assembly and not inconsistent with the standing orders nor with the practice of the National Assembly. If one were to refer to Erskine May's Parliamentary Practice 24th edition at page 344, it speaks to confidence motions. And Mr. Speaker, I won't bother to read that. But it outlined at page 344 how motions of no confidence are to be dealt with. So the primary exigency of government business that is referred to in the budget is the budget debate. They decided that there were some exigencies, and it was the budget debate, which was initially set down for September the 11th. And when the motion of no confidence... December 11th.
2012.
What did I say?
September.
Setting on December 11th, 2012. And when the motion of no confidence was filed, the government panicked. Yes, Mr. Speaker, the government panicked. Let me tell you why I say the government panicked. The night before, on 10th December, Prime Minister Douglas made a national broadcast to advise that the sitting will be postponed because two members of Cabinet, Honorable Sam Conda and Honorable Timothy Harris, had failed to attend a scheduled budget meeting. On December 11th, the Clerk of Parliament sent out a notice stating that the meeting had been postponed. Panic. And I will extend it here by saying they panicked because, Mr. Speaker, they could easily have tabled the estimates and waited to debate the budget sometime in the new year, but they did not know what to do. The Prime Minister has repeatedly and consistently stated in numerous public broadcasts and addresses, including an address to the Chamber of Industry and Commerce on the 18th December 2012, that the budget debate should take precedence over the motion of no confidence. I will slip a few pages down because I want to make it short. I, for one, I wrote to Douglas Mendes, strenuously object to Dr. Douglas moving to gerrymander the boundaries, because at that time, they were setting about to gerrymander the boundaries. I have publicly indicated that I and the majority of elected representatives would vote against him in a no confidence motion, and would definitely like to know the possibility of stopping the commission submitting a report to the Governor General and becoming law. All this was sent to Senior Counsel.
March 2013.
March 2013. I will fast forward a bit because you see, Mr. Speaker, I went on to tell the Senior Counsel, it is now 81 days since the start of the financial year. Why did we say that? Because It should be noted that Section 71 of the Constitution states that minister for the time being responsible for finance shall cause to be prepared and laid before the National Assembly, or not later than 60 days after the commencement of each financial year, estimates of revenues and expenditure. At that time when I was writing to the Senior Counsel, the 31 days, the 2 months, the 60 days after the start of the year had expired. And he had not brought the finances, the budget debate to the Parliament as required by a constitutional Section 71, which is an enshrined part of the Constitution. This was violated. Brought the budget sometime in April and came to this Parliament to make some resolution which was unconstitutional to help pass a law in 2013 so that they could spend money in 2013. I submit, Mr. Speaker, that every dime spent in 2013 was illegally spent because you could not amend the Constitution in April to be able to bring the budget in April. They had long passed that section, that time, which was allotted to them. 60 days. They had until the 1st of March. And so, Mr. Speaker, that case went on from there. What happened after that is interesting, Mr. Speaker. This is why I brought this personal statement. Because, you see, in the end, we decided, let's work with this government. Let's take the matter out of court so that to give them an opportunity to bring this matter to the Parliament as they properly should. And the very government, through its Speaker of this Parliament, decided, no, you want to take it out, put it back. Remember, you know, the Speaker then, Honorable Leader, said, look, you can't tell me what to do. I am the Speaker of this House. No court could tell me what to do. He said, all right, we'll take it out of court and do what you have to do. No, put it back in court.
He took us to court then.
He then took us to court after we said we will take it out of court. And that is why we were here until November this year, you know, because they just wanted to make sure that the proper government that should have been there for 2.5 years almost, they denied us the government since 2012. And for 26 long months, paraded in this country as if they were the legitimate government of the state. And this is why Mr. Speaker, I feel vindicated. I feel vindicated when the decision was handed down by her ladyship on the 7th.
Yeah.
I think all of us who knew that we will vote for that motion of no confidence, that we will have a new government in 2013, should feel vindicated today that we have had that landmark decision that has told us that what the previous administration led by Dr. Douglas, member for number 6, did was wrong.
Very wrong.
A violation of our Constitution.
Yes.
And so, Mr. Speaker, I make that statement because in my own constituency, people have been telling me, what you all went on with that case for? Well, we didn't go on with it for any real reason, you know. Remember I said we took it out of court and they put it back?
Yeah.
So it's not we. We have been vindicated because they decided to put it back so as to thwart what we were trying to do. That's why. And so, Mr. Speaker, the decision came down. And I am pleased on all 6 counts.
Yeah.
All 6 counts.
Good work. Good work.
The court has found that the 6 declarations for which we have asked have all been in our favor. That is significant. A landmark case in this hemisphere. And I feel proud of it, Mr. Speaker. And, Mr. Speaker, cost involved too, eh? We got cost too, yes. Very significant that we got costs. And so, Mr. Speaker, look, this is a topic on which I could speak all day, you know, Mr. Speaker.
Don't do that.
But I will tell you, Mr. Speaker, I'll move to the second subject which I want to make a personal statement about. Yes, Mr. Speaker, with your permission, I want to turn to the second statement. If you will just bear with me a minute. No. But you know, Mr. Speaker, the second statement has to do with the fact that I, Mr. Speaker, was elected in 2010 and was the subject of conduct by the then administration which affected how I conducted myself in Parliament and how others should conduct themselves. Let me explain, Mr. Speaker. I feel duty-bound, Mr. Speaker, to make this personal statement because I don't believe that any member of this Parliament who is by his own act demonstrate acknowledgement of allegiance, obedience, or adherence to a foreign power state ought to be sitting in this Parliament.
That's why I remember for number 6 not here.
You see, Mr. Speaker, I say I'm duty-bound because the publication in a recent issue of the St. Kitts Nevis Observer of a purported extract from a passport issued by the Commonwealth of Dominica to the Right Honourable Denzel Llewellyn Douglas, the elected member for constituency number 6, I have been bombarded since that publication by my own constituents with claims of hypocrisy. And Mr. Speaker, my constituents are entitled to the truth if they are to continue the overwhelming confidence they have reposed in me to be their representative in this chamber.
Go on, member for number 8.
My constituents who are having discussions liken me to the member for number 6, and they're wrong. And that's why I'm making this personal statement, because you can't liken me to what has happened to the member for number 6.
Yes.
Sure, that's different, totally different. No, my honourable friend. The honourable member for St. Christopher 6 is not only elected to serve in the Parliament of St. Christopher Nevis, he is appointed as the leader of the opposition in accordance with Section 58 of the Constitution. And so, Mr. Speaker, I draw your attention further to the fact that the honourable member for St. Christopher 6 was first elected to the National Assembly in 1989 and has successfully contested all federal elections since 1989 to date. The honourable member for St. Christopher 6 served as Prime Minister for close to 20 years. Up to 2013, he had the purported support of a majority of persons elected. From 2013 to 2015, the honourable member for St. Christopher 6 continued to occupy the office of Prime Minister, but this was attributed to the failure of your predecessor in the office of Speaker, not your immediate predecessor, one of your predecessors, to table the failure of him tabling the motion of no confidence. That's why he sat in this government from 2013 to 2015. Had the motion been passed, been debated, he would not have been Prime Minister. And so, Mr. Speaker, in 2009, while serving as Prime Minister, while serving as Prime Minister with responsibility for elections, the honourable member for St. Christopher 6 piloted a bill. He piloted a bill through this honourable House, which was passed into law, which is now otherwise known as the National Assembly Elections Amendment Number 2 Act 2009. The Act introduced a statutory declaration of a person. The Act introduced a statutory declaration of a person nominated as a candidate for elections as a member of the National Assembly, requiring such persons to swear to 11 declarations, including the third declaration, which states, I am not by virtue of my own act, under any acknowledgement of allegiance, adherence, obedience or adherence to a foreign power state. That was set up for Lindsay and Sean. My good, the honorable member for number,
Yeah, your passport?
for
Okay.
number 5, and the honorable member for number 4.
I hope you got holes in it, you know.
He got holes in it, I have to give it to him.
Okay.
And now he got
You understand? This act was passed to prohibit them. They were US passport holders. They had to eventually give up their passport, their citizenship to the United States. This was because the honorable member, as leader of the government and member for elections, leader of elections, minister of elections, determined to pass an act to prohibit them from being sitting in this parliament. Mr. Speaker, the act amends the Principal Act at paragraph 100A by replacing subsection 3. This is what it says. A candidate who commits an offense under this section shall be liable on summary conviction to a fine not exceeding $30,000 or to a term of imprisonment not exceeding 5 years or to both fine and imprisonment. This was passed by the honorable member for number 6 when he was Minister of Elections. It goes on. Shall not be qualified for a period not exceeding 5 years following his or her conviction. Thank you, Mr. Attorney General, for bringing the matter to the court sometime soon. Of course, that part was really referring to petitions, but it doesn't matter. The point is, you could be convicted if you are a dual citizen, if you show allegiance to a foreign power state and still go and swear and get in the parliament of this country. So therefore, it stands to reason, Mr. Speaker, you can't on nomination day, not short acknowledgement, and then come after nomination day and beat the system by showing acknowledgement. It will make a mockery of this thing. And so, Mr. Speaker, I have looked at the offending passport, and I've noticed that it is dated a few months after the holding of the general elections of February 16, 2015, in which the honorable member for St. Christopher 6 was elected by an overwhelming majority, the same elections which resulted in the recent change of government and the belated establishment of the present Team Unity government. I said, put it that way because for 2 years they prevented us from being the government. This would mean, Mr. Speaker, that on nomination day, the honorable member for St. Christopher 6 may well have been compliant with the oath of qualification for membership. And yet, Mr. Speaker, a mere 4 months later, the honorable member for St. Christopher 6, it would appear, by his own act, put himself in contravention of the rules constitutionally enshrined which militate against acknowledgement of allegiance, adherence, or obedience to a foreign power or state. Mr. Speaker, I make this statement as someone who was on the receiving end a few years before. When I got elected, the gentleman who was defeated came up to me and shook my hand and said, congratulations.
Who that?
The member for St. Christopher 8 then was the Honorable Cedric Liber. Shook my hand, congratulations. And then a few days later, he seemed to have been forced to bring a case. Because, Mr. Speaker, they brought a case to court. My colleague as a member of St. Christopher 6 was part of the government on that occasion. Their case was seeking to remove me as the elected member for St. Christopher 8. This was a time when the honorable member for St. Christopher 6 occupied the position of Prime Minister of the government of St. Kitts and Nevis. And challenge was brought against me on the ground that I was perpetrated by my own act under acknowledgement of allegiance, adherence, or obedience to a foreign power or state, namely the United States of America. Mr. Speaker, I was the holder of a mere green card. I have never been a citizen of the United States of America. I had never applied for nor been issued a passport of the United States or any other country. If there are constituents of mine who are still comparing my position in 2010 with that of the Right Honorable Dr. Denzel Douglas, they must take note that I never held a passport for any other country. While Dr. Douglas has a passport for another country, there's a significant difference.
Yes.
Indeed, Mr. Speaker, it was falsely alleged that I held a passport issued by the United States. Fake passport numbers were invented, and a false and corrupt oath was sworn to those fake passport numbers. The allegation was fake news, and it was subsequently not relied upon. I believe somebody ought to have been in prison, and criminal charges should have been brought on someone for those false declarations. But unlike the Honorable Member for St. Christopher VI, who is the holder of a passport issued by another country, I had never had the desire or intention to acquire another country's passport. And yet, I was hounded into court by the government headed by the Honorable Member for St. Christopher VI, whose Attorney General intervened into the hopeless case which was brought to court, the object of which was just to disqualify me. There's every good reason for any constituent and citizen, any representative, and every good reason for the Office of the Attorney General to institute proceedings against Dr. Douglas. And I would expect no less, as I am uncomfortable with having him,
Yes.
anyone for that matter, sitting in this parliament in violation of our Constitution.
Yes.
Section 31A of the Constitution, Section 31(3)(c) of the Constitution reads, an elected or appointed member shall vacate his seat in the assembly subject to subsection 4, if any other circumstance arise. Those are the underlined words. If any other circumstance arise, that if he were not a member, would cause him to be disqualified. So had he not been a member, because if he was not a member, he could not run if he had the Dominican passport. He would be in violation and could be brought up on criminal charges. But that was not so when he ran. So after he ran, he got this passport. Then something has arisen. And because that has arisen, it is enough to disqualify him from sitting in this parliament.
Yes.
That's what it is. And so, Mr. Speaker, it is clear that a circumstance has arisen that was not there when he was elected. The honourable member, my colleague, the honourable member from St. Christopher Parish, said maybe he going to renounce. But the point I'm making, Mr. Speaker, is this case, the member for number 6 has a completely different case to anything that has happened in this jurisdiction so far, including mine. It therefore gives me no pleasure at this time to inform you, Mr. Speaker, that this House, you and this House, that I and my legal team were completely vindicated. Just like we were vindicated on the 7th of November, I was vindicated then. I was vindicated because they had brought a bogus, hopeless case. I do not feel pleasure because I think that the Honourable Member for St. Christopher VI would have been the last person, after what he put to the Parliament in 2009, would have been the last person
Yes.
to find himself in such a quandary.
Yes.
The last person, Mr. Speaker, I hold no water in my mouth to declare to you that it would make a mockery of the Constitution of the Federation of St. Christopher and Nevis if any member of the Parliament can be allowed to take part in the proceedings of this Honourable House while that member of Parliament is by his own act under acknowledgement of allegiance, obedience, or adherence to a foreign power or state. I again call the attention of my constituents to the fact that having been elected in 2010 and again in 2015, I have been properly elected and was and still am eligible and have not been disqualified and face no disqualification for conduct which violates our constitution. I am a member of this parliament. I am not under acknowledgement of allegiance, obedience, or adherence to any other power or foreign state. I am not sure at this point that every member in this parliament, at least one member, the member for number 6, can say the same. May it please you, Mr. Speaker.
Stay up to date with news, programs, and activities of the government with SKNIS. Like us on Facebook. Listen to us on SoundCloud. Follow us on Twitter. And watch our videos on YouTube. Connect with us today. SKNIS, St. Kitts and Nevis Information Service.